questions from last week that you would like to ask? No? Okay. I can only encourage you to really follow up with your studies and repeat the stuff we're doing here, because it's going to be very quick. And as I mentioned last time, I have 3 students that failed the last class. And, yeah.
Can you, I'm sorry, but can you speak a little bit louder?
Okay. I said I encourage you to repeat what we do in the courses and be prepared. I just mentioned I have 3 students from the last course that failed, and they have a hard time now taking oral exams or repeating the test. So it happens. Yeah, it happens. And I don't think I'm too strict, but I require a basic understanding of the stuff we're doing here. And you should really have that and be able to show it. I wish I would have a clean blackboard here, but maybe so. Without that, I want to come back to the point how the SPV is structurally financed and talk about the components a little more so that you have a better understanding of what the balance sheet of the SPV is going to look like. Haben Sie irgendwie so nur Dinge, die nicht funktionieren. So the basic components are of financing on the right side of the balance sheet of a company. What do you find there? Generally speaking, debt and equity. That's right. These are the basic components, debt and equity. Now, equity is not a technical term. Actually, it's there are different kinds of equity on a balance sheet. There are actually 3 kinds of equity on a balance sheet. And I think you should have heard all of this from Professor Kahn in Basics of Corporate Finance. So what are the 3 kinds of equity in the balance sheet? Real equity. I'm talking about structured or hybrid equity in a moment. So what are the 3 categories of equity? Well, the first one should come to your mind quite easily. Share capital. Yeah, that's right. The first one is share capital. That's basically covering the registered capital of a company. I think most corporate laws of the world require a certain minimum capital in the company. And what's the effect of being a registered capital? Why do we call it registered? You cannot use it for distributions. Very well said. That's exactly the case. It is not within the disposition of the shareholders. It has to stay in the company, and it's basically the give for limited liability. Yeah? Limited liability is a benefit for someone running a business, because if the business fails, the creditors of the business cannot go back to the private assets of the entrepreneur. So a limited liability company is one of the biggest intellectual inventions of the world, I think, because it very much enhanced the degree of being prepared to take entrepreneurial risks. If you would have to bet your entire private assets, your home, and what have you, each time you become active as an entrepreneur, many people would just shy away from it. But with a limited liability, this becomes a bit more possible. You have to bet a certain amount, put it into the company as registered capital. That's basically the basis for your creditors, and if that equity is exhausted, the company goes bankrupt, but not necessarily the shareholder will be held liable. There's one. Is that always the case? No, when it's not, when there's not.
Fraud. There's a fraud.
There's a fraud, yeah, there's a fraud. Indeed, there are concepts which we call piercing the corporate veil. That means that the courts take away the benefit of limited liability, and they do that. There are various cases when they do it. For example, if the shareholders take the equity out, although they're not supposed to take the equity out, it's very clear. If they do that, they become liable. And maybe not even for the amount of the equity, but beyond that, for all liabilities of the company, because those corporate laws only give you the benefit of limited liability if, as a shareholder, you respect the concept. So if you're doing deals on and off and take money of the company and put it back and do as if these were all your own funds, the shareholders are not respecting the separate legal nature of the special purpose vehicle, and one effect of this is that courts just deny the benefit of limited liability and look to the shareholders. So if you use the concept, you should respect the concept. So that's very important. That's of course also true for a special purpose company. So separate accounting, just treat it as if it were a real big, viable corporation with its own resources, which of course it hasn't. So, but this was just about share capital, but there are two other forms within equity that you normally see in a company. Well, let's assume you have. Well, if you have a very big company and that's issuing new stock to the market, what is the how does a company determine the price of the stock they issue to the market?
There's the issue price.
It's the issue price. That's right. And is the issue price always equivalent to the registered? No, it's not.
Premium.
There's a premium. Yeah. Because that's exactly right. I mean, you could probably issue shares for just additional registered capital, but this doesn't make sense if the stock trades above its nominal value. If you have a stock that has a nominal value of €1 per share, but the stock trades at 100, you would, of course, as a company, not issue new shares for 1, because your existing shareholders would sue the hell out of you, because they will be diluted. Company would give away a lot of value by introducing new shareholders at a price of the stock that's very, very, very deeply below market price. So you wouldn't do that. You would issue at market price, and the difference. Hat er einen falschen Stift genommen oder was? Nicht, dass wir selben Fehler machen. Bitte?
Er hat einen falschen von der OP an die Überschrift differenziert.
Ja, okay. Ja, das weiß man nicht. Ja.
Er hat jemand einen falschen Stift genommen.
Danke. And so the difference between the amount of the new issue price that's being allocated to registered capital and the actual issue price is what we call premium, share premium. And share premium is an additional item in equity. And the third should be very self-explanatory. What? Retained earnings, that's right. Yeah, retained earnings. That's the third one, is if the company makes a profit and doesn't distribute the profit, you need to do something with it on the balance sheet, and that's retained earnings. So these are the three components of equity, and basically even the SPV and the project finance can have all three of them. It's not a listed company, so it's really indifferent whether you would issue the shares at the nominal value at a high price, or you would create some premium. It also depends a little bit on what shareholders can do with premium. And some, depending on the corporate law, premium may be used to distribute a dividend. So it's in the interest of shareholders to create a stricter tie-up of the capital by saying, it's only registered capital. But these are the three, and they are the level 1 buffer for losses. If the company makes a loss, that means something on the left side of the balance sheet. What do you have? By the way, right side you have all these equity components. On the left side is what? It's the assets. That's right. And that's why it's called a balance sheet. So make sure the number is always the same on the left and the right side. If it isn't, you make a mistake. And so if you have a loss, this basically means in a year the left side has decreased. And the left side goes down, you have to do something on the right side. And what you do on the right side is then you either have a loss carry forward, which is a negative number, and puts the sheet back into balance, or you have a notional loss carry forward, which then is extinguished by dissolving reserve, basically applying reserves against the loss, which brings the reserves down by the same amount. And again, the balance sheet then is in balance again. So that's the first buffer against which losses are booked, and that's why the size actually matters. And that's why the debt equity ratio is important for the gearing, the leverage, and all the things that we have discussed. Now the other thing then is debt. And the difference between if all the assets are represented on the right side by equity, and you have no debt, then you have 100% equity finance, but that's not normal. Companies always have a mixture between equity and debt on the right side of the balance sheet. And as we said, the SPV will have a large amount of debt on the right side of the balance sheet, around 80% maybe of the balance sheet total. And the debt can consist of all kinds of things. It can be trade creditors that just have a claim for a payment of deliveries that haven't been paid yet, or the company has to register the debt until it's paid. Or it can be banks or other financiers that give money to the company to run its business. That's how we always say is that how are the assets financed? The assets are financed by equity and debt. And what forms of finance can we have? We discussed some at the very beginning of this course. Now in project finance we have of course the project loan, that's probably the biggest chunk there. And then we have maybe project bonds. Yeah. I get to those in a moment. Project bonds are, just to give you an understanding, what is basically traded debt, so the issuance of debt securities to the market, which requires a certain maturity, a risk profile of the project finance, because the capital market investors normally have not such a big appetite to really risky stuff. I mean, they take a high yield bond, but not a highly leveraged, not the same kind as a highly leveraged project loan. But these are the two that you see, or maybe some leasing liabilities as well, but it's the project loan, and sometimes you have project bonds on the right side. Now, can you think of anything that's between debt and equity?
Hybrids.
Hybrid, yeah. Explain to me what you mean hybrid.
You issue it as a debt security, and over a period of time, it can be converted into common stock. Or
that's one feature, that it's convertible. Is that a practical example in project finance? Well, it could be, but it's rather not actually. And who would be? Okay, you could have, of course, third-party hybrid investors, but you could also have the sponsors themselves being hybrid investors. That's even more common, at least at the beginning. And why would sponsors actually have an interest in providing hybrid capital to the SPV? Or it could be about bridge loans. No, not really, because bridge loans would be repayable. Well, theoretically possible, yeah, for bridge loan, but normally you would not have. Well, you have bridge loans. We get to that in a second with working capital loans. Maybe I posed the question wrong. Shareholders might sometimes say, or sponsors might sometimes say, hey, you require 20-25% of equity, but we would have an interest to give you some of this as a hybrid subordinated instrument. That's a very, very important feature, is subordination, because the banks would not accept that the sponsors become senior creditors on the same level as the banks. Yeah. Definitely not if this should count towards their equity portion. And what's an incentive of the sponsors to ask for that?
No risk.
Yeah, it's not really, because the banks, we get to the feature of the hybrid debt that's can be recognized as equity in a second. It's not the lower risk profile really. No, the incentive is basically tax. And the reason is that in most jurisdictions, dividends, well, I think in all jurisdictions, dividends are paid from profit after tax. So if the project company would make 100 profit, would pay like 30% tax, so you could distribute 70. But interest is normally paid before tax. Yeah, it's a business expense, and depending on what the tax regime is in the country where the SPV is resident, it may be beneficial to take some of the benefit out in the form of interest rather than dividend. If, for example, the sponsors are resident in a tax jurisdiction that has a lower marginal tax rate than the jurisdiction where the SPV is located, so that the ultimate tax charge is lower than the other dividends. Okay, the banks say, yeah, well, let's discuss that, but we have a few conditions that we would like to attach to this hybrid or mezzanine or subordinated debt that you shareholders put into the company instead of equity. What would these conditions be in your mind? Subordination is one, we already mentioned that. I mean, the banks would want that this comes as close to equity as possible from their perspective. So what other conditions could you think of?
And subordination is one that I think other should be conversion from, it should be mandatorily convertible into equity at some period of time. So they are more closely associated with equity than to debt.
Well, if it's close to equity, the banks actually shouldn't care. You have that when you have third-party investors that get a special value kicker out of the conversion. It's a slightly different market. Yeah, is when you have a third-party investor that takes a share of mezzanine finance with a particular risk, and they get normally another way of return in addition to a high coupon, that is the chance to convert into stock if the financing works out. And it's part basically of their compensation package. But in my scenario, where the lenders are the sponsors, that's not really relevant because they already have the the value in the stock and whether it's stock or not should not play a role. But what other conditions can you think of? I mean, the first thing that I said at the beginning is that equity should be reserved for the creditors. So the first thing that I would tell the sponsors is you cannot take it out. Yeah? So it cannot have a fixed maturity, or the maturity must be postponed to a point in time when the financing is repaid. So you cannot take the money out before the bank loan is fully repaid. I mean, that's one requirement, because for equity it's the same. You cannot take it out. Yeah. Now we talk about principal repayment. What other? Now the other one, of course, is interest. Yeah. I would tell the banks, well, if you either cannot take any interest at all, that means you have to roll it up, carry it forward. But perhaps if the project works very well, we may allow you to take some of this out as interest, which would be nice for the sponsors, because normally they could not get dividends. But it must be very clear that interest cannot be paid if cash is short, and there's not enough to pay interest on a subordinated loan and the senior loan at the same time. So if money is short, there must be a clear rule who gets what first. Yeah. So that's the second, and closely connected with the second condition is the third condition, and saying that your subordinated loan agreement must draft it in a way that when interest is being postponed, there is no right to declare default or even put the company into insolvency. Yeah. Because if the shareholders would have the right to declare insolvency, they could really blackmail the banks. Yeah. If their interest is pushed back to a time when the company is a little better off. So the law must be drafted in a way that this is always possible without creating default. Yeah. Now we said the loan must be subordinated. What does subordination actually mean, or what two kinds of subordination are commonly distinguished? What does subordination mean technically?
It's not a senior debt, it's a subordinated in the sense if cash flows are coming in, if bankruptcy happens, the first tier has to be satisfied, and only then whatever is left goes down to the second tier, that is subordinated debt.
Yeah, that's right. I mean, you touched actually on both, but the one that you described at the end, indeed, is subordination in insolvency. It creates a certain level where that debt can be paid by the insolvency administrator. If something is subordinated, it means that all unsubordinated debt, all senior debt, will have to be paid out first in full before anyone that holds subordinated debt gets any payment. And if subordinated debt is fully paid and still something is left, that goes to the shareholder. So you have a clear level. That's just the flip side of the fact that equity is a loss buffer, and so it has to be paid out last in insolvency. And that we call that subordination on a gone concern basis. But that's not enough, actually. I mean, if subordination would only really materialize in insolvency, it would not be really valuable, because nobody wants to go that far as to insolvency. I mean, that this is only really the last resort. And so some of the elements that I have all of the elements, or let's say the element 2 and 3 of subordinated debt that I've discussed, are another way of subordination. And that's the one that you have just mentioned. That is a subordination on a going concern basis. where you also establish a certain ranking of the various liabilities. And one of this is that if cash is short, as you said, senior is paid first, and subordinated creditors have to wait. Yeah, and the same applies to the repayment of principal. Only repayment of principal once senior is repaid in full. So these are these levels on a going concern basis. Now, how do you establish subordination on a gone concern basis? How do you make sure it works? Well, in most jurisdictions, you just say in the instrument itself, in the debt instrument itself, says it shall be subordinated, and in most jurisdictions, the bankruptcy administrator then knows and is bound by that stipulation that he has to pay out all senior creditors first, and then he can look at the pot of subordinated creditors and pays them second. So that should normally work. But what do you need to do with respect to the going concern subordination? Intercreditor agreement, yes, very well. So that the instrument there is an intercreditor agreement, is where different classes of creditors enter into an agreement and agree on just these things, especially level 2 and element 2 and element 3 of subordination that I have mentioned, because you can't do that by just creating subordination in insolvency. You need to do something earlier. And an intercreditor agreement you need also when you happen to be in a jurisdiction where subordination is not recognized in insolvency. That sometimes happens. There are some jurisdictions where insolvency administrators still have to treat subordinated and senior creditors the same, simply because the law does not recognize subordination in insolvency. And how would you, if you are in a jurisdiction like that, how would you deal with that in an intercreditor? Any ideas?
It's kind of a contractual obligation. If they haven't been writing their agreement, then those creditors, senior creditors should, those subordinated creditors should pay back those money to those senior creditors.
That's exactly right. That's the way it normally works. If insolvency laws do not recognize subordination, that means if the insolvency administrator starts to liquidate and distribute the assets, subordinate creditors and senior creditors will get the same amount of money at the same time, proportionally to their debt. And that's not in line with what the parties have agreed. So there are two ways of doing it. Either, and that depends technically on what the insolvency, what's better under the insolvency law. You either can force the subordinate creditors to pay it back to the administrator, so that in the next round of distribution, it's again relocated, and that's a circle, until senior is paid, or you require a subordinated creditor to give the money to the senior creditor. Why does it matter? It matters because in the second case, it may be that the subordinated loan is already satisfied, so the subordinated creditor is losing its claim against the bankruptcy estate by giving the money to the senior creditor. So you have to work out carefully that for the two of them, it still works out. Yeah. And that is very much a question of the local bankruptcy law, and that's too much detail for now. But I want you to remember that there are jurisdictions like this where subordination is not recognized, and you need to deal with this in intercreditor agreement. And there's some other elements in intercreditor agreements that are important. For example, the obligation not to put the company into bankruptcy, or not the obligation, or the so-called standstill obligation, not to, or when you have a third-party creditors are not the sponsors, they will normally not have security in the project company, but if there's a third-party creditor, you also have regulation about what happens when there is an enforcement event and who has the right to decide if there's enforcement. Normally, the senior creditors are in the driver's seat before junior creditors have a say. Now, they normally have to wait at least 6 months before they can to give senior creditors the right to work out the financing. So that's so much about subordination, and now we want to briefly look at a slide. This is summarized. So you can see that here again. With the various advantages and disadvantages of the various components of debt. So from the bank's perspective, basically, so they like equity because you have no continuing interest obligation that you would have to deal with in the credit agreement first, because they can only be paid out when there are profits. But even then, banks would normally not allow the payout of profits unless there is a huge buffer of equity available, because the banks like to have rainy day funds in the project company. So as a general rule, as long as the senior creditors are not fully repaid, dividends are a no-go, unless you really have piled up a huge amount of cash, in which case the sponsors may be allowed to take it out. Special tax treatment for certain types of equity investment, that very much depends on the tax jurisdiction. Restrictions on company activities only in the constitutional documents and shareholders agreements, so not in the contractual agreements, which is nice for the sponsor side. Shareholders are willing to bear higher risk because of greater potential return. That's the leverage effect that I mentioned at the very beginning. Disadvantages are that they are not tax deductible on the sponsor side, and on a winding up, of course, equity is in the lowest rank. Now, senior bank loans can be relatively flexible in timing. That means when we look at how a loan agreement is structured, we'll see that although the loan agreement has a certain amount and a certain term, it's normally flexible to also allow for early repayments. So if the project's going very well, the company can pay down the loan quicker than originally expected, which is good from both sides. The banks have the chance to reduce their risk faster, and the sponsors have the opportunity to reduce the leverage before the time. Can be cheaper than other sources of finance, that's certainly true, provided there's sufficient security, interest is tax deductible. Project company may have an existing relationship with the bank, or the project company would normally not have a relationship because that's a newly set up SPV. I should correct that to the sponsors may have a previous relationship with the bank. There is no need for a credit rating. That's in difference to project bonds. We get to that in a second. And there's a minimum of public disclosure requirements and regulatory approval. That's also in contrast to bonds, where you have a lot more public information available because you need to provide investors with that information. On the negative side for the sponsors, extremely restrictive covenant packages. we'll talk about covenant packages, I think, in the next session that we have, especially financial covenants. That's very important for you to understand what financial covenants are. Extent of security rights and guarantees, fees and costs can be very high, and documentation is normally complex and onerous. So a project finance loan agreement has very, very rarely less than 200 pages, often much, much more. And now for project bonds, advantages. Easily accessible source of cash flow when money is tight in the bank markets. So often you have a situation when banks' appetite to incur more project loans can be reduced, while the capital market for bonds can still be open. You normally have quite long maturities, 5, 7, or even more years. High yield returns secured by productive assets. That's more on the investor side. Looser covenants, certainly, because bonds have inevitably more anonymous structure. You have a couple of thousand bondholders, and although you have a trustee, you cannot exercise the same amount of control than a bank syndicate could exercise. So that's a good point for the SPV, that they have creditors with less influence over their business. Looser covenants, bondholders not so much concerned with day-to-day monitoring. But all of this looser covenants and this release of less involvement of the debtors into the business shows you that that's only a way actually when the risk has come down a bit. In the initial phase, and particularly in the construction phase, it's inconceivable to have bond financing. So bond financing is a way of refinancing somewhere in the middle of the project. But not initially. Highly regulated because you need to protect the potential investor. You need a big prospectus. You have prospectus liability. It's difficult to negotiate because of this anonymous group of bondholders. It's easy to negotiate with a banking syndicate, but it's very difficult to negotiate with bondholders. Difficult satisfying disclosure requirements. That's always a predicament. You have to tell the bondholders everything that's relevant for the investment. On the other hand, there may be very many confidential elements in the project finance structure that you're not allowed to disclose, for example, government agreements and other things. And that's maybe a difficult gap to bridge, because if not everything that's relevant for investors is in the disclosure materials, the SPV would become liable as an issuer. While the bond rating, rigid financial structure, which can limit the scope of the refinancing. Yeah, that's, for example, possible when you wish to refinance the senior loan, but you have covenants in the bond that would not allow you to do that. And then you would have to change the bond terms and have to go back to the shareholders and have to the bondholders and have a bondholders meeting. And repayment is normally very strict on an annuity basis, so you have very firm coupon payments, whereas in bank finance there is normally much more flexibility to skip a payment if the times are not that good. So these are the pros and cons of the various financing elements. You don't have to memorize all of this. I just want you to introduce you to these three basic things. Whereas the shareholder loans are part basically of equity, as I just said, they count towards equity, and they should be structured as similar to equity as possible. So there is not a separate category here. So equity comes from the sponsors, and the bank loans and the bonds come from third parties that are not sponsors. So these are the basic. So any questions to that?
I have a question regarding project bonds. I mean, in order to issue project bonds, you have to be a listed entity.
No. Well, it depends on jurisdictions, but certainly not here. There are many companies that are, for example, family-owned companies that have listed bonds.
Okay.
So you can list bonds only. Listing of bonds and shares are two different things.
Okay.
Yeah. Of course, often you find listed companies among bond issuers simply because these companies are big enough to go to the market and take up a bond of 200, 300, 500 million. And those companies are just oft listed by way of size, but especially Germany, which is famous for its family-owned businesses, has other examples. I mean, if you think about Bosch, for example, 150,000 employees, of course, has bonds on the market, but it's family-owned. Okay, sponsor support. We're going back to the beginning, and we said that the major feature of project finance is what we call limited or non-recourse financing, and when we say limited or non-recourse financing, we always mean this from the perspective of the sponsors, and of course not from the perspective of the project company, to which the banks will always have recourse. And non-recourse is probably never a right term, but limited recourse is, because there's, even in the simplest structure of project finance, there will always be recourse to the equity that the sponsors have put into the project capital. That's basically the money they are betting on the project. Now, in most cases, this will not be enough. So there will be other forms of support that banks require for the project to be developed and to go forward, because the SPV, as I said, doesn't have its own resources and could not basically stand on its own. And there are many different ways of sponsor support, but there are a few ones that I would like to go through with you. Again, some of them we have already mentioned, like the supplier pay agreements. You already know what that is. But the completion guarantee is a very important one. The completion guarantee is a very important one. Very, very common to project finance structures. And the reason for the completion guarantee is the following. Often banks say, well, you have a very nice project, and we believe that if the project is finished, this will be a nice investment, because the market for the product of the project is fine and is promising, and so we think that's fine. But, they say, but the construction is something different. Yeah. It's going to take time, many things can happen. Yeah. So we would be on board, provided that during the construction phase we need some other company. Yeah, we need some other company. And that comfort is given in the form of a completion guarantee. Completion guarantee means that the limited recourse concept is postponed until completion. So it's a full-blown guarantee that gives full recourse against the sponsor until completion is achieved. And the content or the way it's drafted can either be a real guarantee that completion will be achieved, or a guarantee for repayment of the bank loan. So if the banks basically go out before completion, have to go out before completion, and in that case the assets, although security will already have been created, will never be enough to repay the banks, because if you have a half-finished power plant, that's difficult to sell. And it's very, very unlikely that even with a 20 or 25% equity, the value of this half-finished investment is good enough to repay the senior bank loan. That's already been dispersed at the time. So another way, rather than guaranteeing completion, is a basically repayment of the loan guarantee or payment of all amounts owed under the loan if there is a default before completion. Now what's tricky actually is, what does completion mean? And you see here already the magic word. Completion is normally defined by a so-called performance test. And that requires very, very careful drafting, because the effect of completion occurring is very relevant for the banks. Obviously, according to the concepts, the project must be somehow finished, somehow. So it must be ready to produce and generate its own revenues, but not necessarily at full capacity at this time. So you define a certain test criteria. If these are satisfied, the company should be able to stand on its own and should be able to satisfy the debt service as it becomes due, matures from its own revenues. And that can be a very, very technical test. For example, in this case of the project finance of a telephone network that I did a number of years ago, it's very difficult to measure, when is a network. It's never completed actually, because you never have a base station in the backwoods or in each corner of a forest, so you needed to have enough capacity to create a certain amount of customer usage and hence satisfaction that creates enough revenues for the banks to really say, okay, now they can stand on its own. And it was a complicated test with experts going to various places in the country and measuring how long does it take to establish connection with the network and what's the quality of the voice transmission and so on. So then, that's, for example, criteria that you apply for a project in the form of a mobile telephone grid. It's probably easier for a power plant where you just measure how much electricity comes out over a certain period, or for a refinery, which seems very straightforward. But still, you need to have experts that check the project very intensely to find out whether a standalone operation is possible. So you should actually remember what a completion guarantee is, and that completion is a tricky issue and needs to be negotiated very, very carefully. The other thing is working capital. What do I need working capital finance for?
Day-to-day working of these projects.
Yeah. So what's typical for working capital finance? Or as distinguished from CapEx finance?
Yeah, as assumed, CapEx or term loans, which are long term, these are short terms.
Short term, yeah. Short term. Why? Because working capital requirements go up and down. Yeah. CapEx finance, capital expenditure finance, is a long-term finance because you have a huge expense for a capital good. That's an investment good that is going to be used over a long period of time, and hence you need to have a stable financing, either for the lifetime of that asset or for at least a sensible time that is long enough for the borrower to amortize the loan. But working capital is going up and down. Why is that? For example, you have a system where your customers always pay their bills in the last day of the month. but your employees expect payment on the 25th of each month. Yeah, you have inevitably a gap in cash availability that needs to be bridged, because you have to pay your employees on the 25th and money's coming in on the 31st. You need to have a 6-day loan, but not more. And you don't want to have your entire payroll expense sitting on your account just for the 5 or 6 days where you actually need it. Ideally, you would like to draw the loan for the 6 days and then repay it. And that's the typical functioning of a working capital loan. It's a short-term loan that goes up and down all the time and helps the borrower to manage its short-term cash needs without becoming too expensive. Does that mean you don't have to pay anything when in the time periods when the working capital financing is not used? Of course, you have to pay still something to the bank, and that's what we call a commitment fee. So for the bank to stand by and being available with a certain maximum amount to disperse during these times is a service that has a cost. And it also has a cost for the bank, because I'm sure you've heard that banks have a regulatory capital requirement. So banks must maintain a certain minimum capital, which is calculated as a function of their assets. And assets are calculated for the purpose of the capital requirement, not in the same sense as balance sheet assets. That means an undispersed working capital commitment would not be an asset on the balance sheet, because money didn't go out, and so you don't have a customer you have a claim against, so there's no asset in the balance sheet. But regulatory laws are quite inventive. They say, from our perspective, it doesn't make a difference whether you have to disperse the loan or you are required to disperse the loan. The risk position is the same. So regulatory-wise, a commitment is treated like a dispersed loan, maybe at a lower multiplier, but it's treated basically like a dispersed loan. That means also commitments need to have capital put against them. And so the bank has a cost to finance the commitment. And if not for any other reasons, that's why they want money for commitments.
So if the expense gap is like before the next tranche, so can the sponsors provide the required expenses as a loan to the project company, and then once the tranche is received, then the sponsors can get back their...
Yeah, that's exactly what we're getting here. That's exactly the point. I was just explaining what a capital line is for the banks, and now how does this translate into project finance? Now in project finance, the banks may not be really interested in doing this for a number of reasons. One is they're happy to provide a US dollar or euro loan to finance the equipment, but working capital loan requirements often occur on a local level in a local currency. Yeah, as I just mentioned, when you have to pay your local employees and you have local revenues, the working capital requirement is actually in local currency. And depending on where the project is located, banks have big international banks may not have a subsidiary there. Yeah, they may not trade in this currency. So it may be very unattractive for the syndicate banks to actually try and also provide working capital loans. But if the company leads working capital loans, they will allow the sponsors and require the sponsors to do that themselves. Yeah. Require meaning the sponsors need to be available to bridge these gaps by providing cash to the company as and when needed, but in difference to the hybrid loans that count as equity, they can take it back if there's enough cash. Normally, shareholders cannot take back money that they have invested into the project company. That's going to stay there, tied up, until the senior banks are paid. But this is an exception, because they're treated as if there were a local bank to do that, and they should not be worse off than the local. So they can provide the funds and can take it back if there is enough cash. And the banks like the idea, and for the sponsors that's also okay. And sometimes the sponsors might even benefit from the collateral package, so they might even be treated as a lender on the same level with this working capital line, so if the project company goes bankrupt, they might be even sharing in the proceeds from the collateral. But this is also a very specific form of sponsor support that you see quite often. Now, comfort letters, that's an interesting concept. Can anyone describe what a comfort letter is?
Sometimes it's a parent company which comfort letter to the creditor with subsidiaries. Most times the comfort letter is no binding. It's just like literally just a comfort. Because
can you formulate one, for example? Have you seen one?
no,
But you understand the concept, yeah. It's let me distinguish what's not. It's not a guarantee, because a guarantee given to a creditor is, for all practical purposes, a first demand guarantee. A real guarantee, that means the beneficiary of the guarantee doesn't have to produce a lot of documents or anything, can just say, I have money come to me and it's not been paid, so I make demand upon the guarantor, and the guarantor simply has to pay. That's a standard first demand guarantee in the national finance market. A letter of comfort is not something like that. It's less than a guarantee. But I think, as you mentioned, there are two letters of comfort. One that are still drafted in a way that could create, at the end of the day, a money claim against the issuer of the comfort letter. And that's what we would call a hard comfort letter. And what we call a soft comfort letter is really just a way of comfort, but it does not give any money claim against the issuer of the soft comfort letter. So it's not very valuable for a creditor. It's basically just a matter of honor, if you violate a soft comfort letter. So it's not there. But sometimes it's better than nothing. Now, a hard comfort letter could be like, it's part of our business policy to treat the liabilities of our subsidiary as our own. That's a very hard comfort letter, because this basically means if our subsidiary cannot pay, we treat its liability like our own, meaning we will pay. A soft comfort letter would be something like, it's part of our business policy to conduct the business of our subsidiaries with the highest standards. That doesn't say anything, because unless you can prove that this wasn't true, that they really have acted negligently when managing their subsidiary, which may be very hard to prove, but if they didn't do this, they did not accept any liability beyond that of a shareholder, so it would be impossible to make a claim against the issuer of the comfort letter under this formulation. And there are as many versions in between those two as you can actually think of, and sometimes parties negotiate the wording very controversially, and there are cases where they finally settle on the wording where the beneficiary is convinced it's a hard one and the issuer is convinced it's a soft one.
But even though it is a hard confirmed later, but the creditors still have no plans towards the parent company, right?
Well, they have. As I said, we have this hard one saying we treat liabilities of our subsidiary as our own. That means if the subsidiary does not pay, they can turn to the parent company and get payment. So hard one means there is an enforceable claim, either directly or at least a damage claim for violation of obligations that were undertaken in the contract.
But when they provide soft letters, they might provide a warning or a disclaimer saying that this does not mean that the parent company will take on liabilities related to the.
Yeah, that makes it very clear so that no court can get on the wrong track and interpret this in a way they didn't want to, and that could be an interpretation aid for the user of the letter and the court that has to make a decision on that. That's possible. Yeah. But again, I mean, if you have this kind of language, it's really not more than a claim of honor against the issuer, which may not be worth anything.
In situations where there is no parent company, can this be issued by private shareholders?
Yeah, of course. Yeah, it can be by anyone. I mean, indeed, when you have three sponsors, you may not have technically a parent, but it's easily possible that the sponsors will give that either as joint issuers or one by each of them. And it can also be, or the content of a share of a letter can also be that they remain invested, they're not going to sell their interest, which can also be of interest to the banks. There will normally be, project finance, there will normally be a really hard enforceable commitments that they stay involved, so that's not, you're not going to get away with a comfort letter on this. But in other forms of financing, this is often the content of a comfort letter that they stay involved with the subsidiary until the loan is repaid, because banks rely on the standing of the parent company often. And it's a hard decision for a global company to let a local subsidiary go bust, and it happens very, very rarely because it's very bad for the reputation. As I mentioned at the beginning, banks like to look at borrowers groups, and to ignore the fact that this is 100 or 200 different companies with limited liability, because they rely on the principle that good borrowers would not just let any subsidiary go bust anyway. And so they always would, even if they would withdraw from the jurisdiction, they would make sure that everybody is paid, and then do an orderly wind down of the company.
And the street conflict is obliged to the bank, or is obliged to the subsidiaries?
Can be both.
Can be both.
Can be both. Of course, if it's to the subsidiary, if you are a creditor, what do you have to do if it's to the subsidiary? How would you try to get to the value that's embedded in the contract?
I mean, if it's to the subsidiary, the creditor only have the contractual claims between the creditor and subsidiary.
Yes, yes, and so the only way to get that is either try to attach that in a way. You can attach these claims, and you can also normally attach the right to make a demand. So you can try to attach the right of payment and the right to make a demand, and then make a claim to the issue of the comfort letter in the stead of the subsidiary. That's one way. Or if there is a bankruptcy, the bankruptcy administrator would have to do that. If there is a remaining claim for the benefit of the estate of the former subsidiary, the bankruptcy administrator would have to realize that value by making the claim. And sometimes you find comfort letter-like declarations not only in the form of a document that's given to someone, but very often you find it even as footnotes in annual reports, especially in bank groups. You sometimes find certain subsidiaries that have a little asterisk, and then you find a statement below by the parent company having the effect of a hard comfort letter, because they know that these subsidiaries need refinancing conditions similar to that of the parent. And so they want to dispel any concern that these subsidiaries could be left out in the dark if something goes wrong, with the effect that the credit risk of the subsidiary would be higher, which is not what the parent company wants. So they make it very public that they treat the liabilities of these subsidiaries as their own, and that has a positive impact on the refinancing conditions for that subsidiaries. Okay, this is just a repetition, take or pay contracts. Very possible that you'll have a question and a test about them, what the actual effect is, and what students often get wrong is that they seem to think that take or pay contracts would also require the off-take party to make a payment if there is no product offered, which is normally not the case. So all the take or pay contracts actually cover is that if there is an output that's sellable, they will sell it, even if they don't need it. It will not cover operational risk, because if take or pay would also cover operational risk, in other words, would also cover the risk that the project is down for a certain period, it will basically be a guarantee. It will be a revenue guarantee. But that's normally not the effect. So operational risk stays with the SPV and hence with the banks financing the SPV. Normally the amounts under a true take or pay agreement would be at least sufficient to service the obligations under the financing, the operating other expenses of the project. It very much depends actually on the size of the output and the market price for it. But that's certainly the intention of the banks, and that would give the banks a lot of comfort. But you can read all that stuff yourself. And throughput agreements, I think I mentioned, also is more for the pipeline stuff, where it's basically works the same as a take or pay agreement, but it relates to the usage of a pipeline. And the same you have on the input side if a sponsor is a supplier of a certain good that the company needs to operate, for example, natural gas or crude oil. So you have the same the flip side of the coin, but the same kind of obligation that can be taken over. Okay, let's we still have 15 minutes, so let's talk about contractors' bonds for a second. Although this is typically part of security, but I just want you to understand what the concept behind contractors' bonds is. We said at the beginning that project finance is very much about structuring and managing risk, and structuring risk away from the project company. Now, you can do this by having other parties in the project finance take particular responsibility. In that context, we mentioned an EPC contractor taking the obligation to provide a turnkey project. That means fixed time, fixed price. So that's all good as the EPC contractor is financially. Now, how can you enhance the creditworthiness of the EPC contractor or the operator or anyone else? And here's where contractors' bonds come into play. Have you ever heard about this contractors' bonds concept? Well, the concept is, or deals with various problems that you would normally have. Let's assume you have an EPC contractor, and the EPC contractor misses a milestone time-wise in building the project. So if you would just have that, just the obligation to finish a certain part of the project by that time, and that obligation is breached, what would you have to do? Or what can you do as a counterparty that's negatively affected by that breach?
Ask for damages.
What?
Ask for damages. Damages.
Yeah, well, you can basically ask for that. You can sue the company. Yeah, and first you have to go to court. They say no, blah blah blah. You have to sue them, yeah, and you have to sue them for damages. First, going to court may take a lot of time. Yeah. And then what's the problem with damages? The calculation may be quite tricky. You know, what's the actual cost of having missed the milestone by a month? You know, is it the extra financing cost? Is it lost revenues? I mean, you can really get lost in arguments about calculating damage. And these two problems are addressed by contractors' bonds. The problem of litigation is dealt with by having a contractor bond issued by a bank in the form of a first demand guarantee. So I don't have to go to court. I can just make a claim on the bank of the contractor in the form provided in the bond, basically saying, you know, you only have, if you declare that a certain date was missed, we will make the payment. So you can deal with the this element. And the second is, how do you deal with the calculation of the damage?
Would it be like have a percentage of total contract price of a particular contract?
Or anything, how do you call that? Liquidated damages. Yeah, that's the term. You know, you provide for liquidated damages. Liquidated damages is nothing but a pre-agreed lump sum compensation for damages that may occur as a result of a certain breach of contract. Yeah? But it makes it very easy. You can just say that you pay 10,000 euros per day by which that milestone is missed. That's liquidated damage. It's very easy to prove, and you have very easy access to the cash. So that's the benefit of a contractor's bond, and that's why they are quite common. And that's also, I think, in this complicated picture that I showed you at the end of the last session. You also have this contractor's bond, and you have then another set of banks, namely the bank of the contractor, that has to issue the bonds, that has its own interest, and that will take part in the negotiation of the contractor's bonds in order not to be exposed. Now, what can you do? Let's assume you are a contractor, and you hear that the special purpose company wants to draw the contractor's bond, but you disagree. You say, no, we haven't missed the date, or whatever the reason, just the event giving rise to the right to draw the contractor's bond did not occur, what can you do? Right. How can you prevent the drawing of the guarantee? Can you just tell the bank, don't pay? No, that's the point. You cannot tell the bank, don't pay, because the bank has undertaken its own genuine obligation in that bond to make the payment if certain requirements are satisfied, and these requirements will not involve any act on the part of the project company. Because if that would involve any act on the part of the project company, the bond would be useless, because they would be back to square one. So if the if the bond would say, you know, this happens, you can demand liquidated damages, provided the project company agrees. We'll be back to square one, because you would have to sue the project company first. So you will never find any act that's necessary on the part of the principal debtor. It's an abstract obligation, and that has certain consequences. It has the consequence that you cannot just tell the bank not to pay. If the bank receives a demand that's in line with the project bond and has to make payment, all you can do is basically issue an injunction either against the bank, and in that injunction you would have to prove that the beneficiary of the project bond is really abusing the instrument for an illegitimate purpose. If you can prove that, courts would be willing to issue an injunction, or for the same reason you can issue an injunction to the beneficiary of the project bond itself. But that's often not as easy accessible as the bank, because the bank is often your bank. As a contractor, it's in the same country, and so sometimes you find the odd situation that the bank says, well, you know, we also are suspicious that this is not right. Why don't you obtain an injunction against us that allows us not to pay? Well, this is a real practical scenario that the bank invites its customer to sue the bank in order to prevent the bank from paying. The kind of project bonds, I mean, the ones that we have just discussed are performance bonds. There are also other kinds of bonds. What is the advance payment guarantees? Often EPC contractors require advance payments to finance the procurement of goods, and you also want to be collateralized if during that period a contractor goes bankrupt, because, as you know, an advance payment would disappear in the general estate of the contractor, and you would be a normal creditor of the estate unless you have a certain security, and that's another purpose of providing a bond for the SPV of the sponsors, so they know they have a security for that repayment, or maintenance, which is basically guaranteeing warranty rights. Now, security will be another separate whole day. I think next week I would like to go through with you the elements of a loan agreement. So we'll talk quite extensively how a financing agreement actually works and what the technical elements of it are. And once we've done that, we will take a closer look at the LMA standard. Have you heard about LMA standard? Does it ring a bell? Well, just so much as an introduction to the topic. Loan agreements are comprehensive these days. The reason is that the financing community has become quite global. And in former times where financing was more national, both parties knew what the national law was, so they were satisfied just with the application of the national law. For example, the German Civil Code has provisions regarding loans. So if you have just a German lender, a German borrower, you don't need to spell out all that's in the code. You just say, and this was actually the fact, like 30 years ago, you would have a letter from Deutsche Bank to BASF and say, we herewith confirm that we are available with a credit line of 3 billion euros for the next 10 years. Yours sincerely, Deutsche Bank. Yeah, that was basically it. Yeah, unconceivable today. Unconceivable. Today you would have always international syndicates, and they want self-contained agreements. That means agreements that are self-explanatory, that have an answer to every question that comes to your mind, and that makes them very comprehensive. Now the next step was that each law firm had basically its own standard, or each bank had its own standard. And some were putting in the front, and others putting the same stuff in the back. So when you had to negotiate, or when you had to read through one of these agreements, it took you a lot of time because you didn't know where to find things. Yeah. And also, believe it or not, but when I started my practice, there was, of course, no word processing. But it was not even common to blackline changes that were made. So the other lawyer would just send you a 100-page contract, in parentheses, find out where we made changes. And so you were sitting there with your secretary reading it word by word in parallel to first find out first what they changed. Yeah? It's unconceivable how inefficient this was. Of course, we're beyond that. And like 20, 25, maybe 30 years ago, there was a organization called Loan Market Association, or briefly LMA, it's London-based, and they said, we need to define a certain master document that everybody's using. That's flexible enough to be adaptable to each and every financing situation, but that's everybody's using, and where things are always in the same place. And that's the so-called LMA master agreement. And there's a set of master agreements for leveraged finance and for non-leveraged finance and so on. And if you join the LMA as a member, then you're a law firm, then you can download these masters and can adapt them very quickly. And if you have an LMA master, it takes you maybe just half an hour or so, if you are experienced, to find out what the specificities about this financing are. And that's very, very convenient. And that's why I want to go through this LMA agreement with you. I think it's on the website, so for you to look at, and I think also one of the documents that you can use in the test. That's a real helpful invention. But before, I first want you to understand the mechanics of a loan fund. Okay, let's see. Attendance list.